Welcome to the webcast. Feel free to ask your questions during the presentation by entering them in the space provided. We wish you a good webcast.
Hi, everyone, and welcome to this webinar. My name is Audriane Barry. I am a litigation associate here in our Montreal-based commercial litigation team and also a member of our class action defense group. I'm joined today by my learned colleagues, Maître Jyoti Chakraborty and Maître Gabrielle Melançon, who are both associates in our commercial group, in addition to our privacy and data protection team. So just to give you a bit of background, our BCF privacy and data protection team advises and assists clients with adopting and implementing the necessary practices, policies, and procedures in order to comply with the applicable privacy laws, whether it be in Quebec, Canada, or internationally. Our litigation group and our crisis management team work hand in hand with our privacy and data protection team in various capacities, whether it be developing privacy-related strategies, advising on managing data breach incidents and the ensuing reporting obligations. We also mitigate litigation risks and represent clients in privacy-related litigation that may arise following an unfortunate data breach incidents or the mishandling of personal information. So today we have the pleasure of discussing a current, quite hot topic, that is the recent amendments to the Act to modernize legislative provisions as regards the protection of personal information, or more widely known as Act 25. So this presentation is meant to be a more informal dialogue between my colleagues who will briefly take you through Act 25, its application, and the various obligations that companies should be mindful of, with a particular focus on the recent provisions that came into force on September 22nd. So over the course of this presentation, we of course invite you to ask us any questions you may have in the discussion chat bar, which I will put to my colleagues over the course of the presentation. We've also reserved some time at the end for a Q&A for any additional questions. So otherwise, we highly encourage you to contact a member of our team with any specific questions you may have concerning your business, and we will be glad to assist you in the best we can. Lastly, as some of you may be wondering, we will in fact be providing you with a key summary of today's presentation over the course of the next few days, which will also include a hyperlink to rewatch this presentation. So on that note, we hope you enjoy this webinar and happy listening.
Thank you very much, Audriane. Welcome, everyone. We're happy to be here. So, Jyoti, I know we don't have much time to cover all the topic of Act 25, but let's just jump into it. What is Act 25 and what gaps does it fill?
Absolutely. So given the limited time, as you said, let's just get right into it. So as you may know, Quebec already had a privacy legislation in place, but it was overhauled because prior to the recent overhaul, it was quite outdated and not in line with present business realities that didn't account for technological advancements that have occurred at least over the past decade. Act 25 now modifies all Quebec-based privacy legislation that's applicable to both private and public sector, and it's more akin to the GDPR in Europe. The Act takes into consideration the technological practices and tools that are now ingrained in businesses today. Given that we have limited time, we'll be focusing on key new privacy-related obligations related to private businesses. On behalf of the team, we of course want to mention that the path towards compliance may look different for each business in light of the type of personal information that your business may collect and process, your operational structure, and measures that you may already have in place. Our presentation is really meant to create awareness and provoke positive action within your organization. Our team is here and available to assist and guide you with customized plans suited to your business. Please don't hesitate to contact us after the presentation.
So what are the more general objectives behind the adoption of the Act?
So at a high level, Act 25 does several things. It grants extended rights to individuals as regards the access to their personal information, rectification of their personal data, and understanding in a transparent way how the data is being used and managed. It also creates obligations that promote and urge companies to be more transparent regarding the use of collected personal information. Thirdly, it also creates new obligations that in turn create a higher standard in terms of protecting personal information that's more in line with the digital era that we're living in. And finally, it imposes substantial fines for non-compliance.
So it's certainly not the first time that our audience heard about Act 25. When did it come into force? And is it true that it gradually is coming to force?
So that's actually a really great question, Gabriel. Act 25 has indeed progressively come into force. The first set of obligations came into force on September 22nd of last year. Another significant set of obligations came into force this year, and a last set will be effective in September of next year.
So before we go any further, can you tell us what exactly is a personal information and how is it defined in the Act?
Absolutely. So right now, this presentation, and it may be quite obvious, but it deals with personal information. So here, we're not necessarily worried about, businesses' financial statements or other kind of technical information related to the business. We're talking about personal information, that is any information that relates to a natural person, so an individual, a human, and allows that person to be identified either directly or indirectly. And I think it's important to mention here that the concept of indirect identification is new. This means that while a given piece of information may seem quite insignificant in isolation, when combined with other information, can make it possible to identify an individual.
So if we focus on the private sector, although there's similar obligations for public bodies, which businesses are covered by the Act?
Essentially, all businesses operating in Quebec that are collecting or processing personal information are covered by the Act.
Oh.
My apologies. So, Jyoti, given the strict obligations that arise or that stem from this Act 25, would an SME be subject in the same way that a multinational corporation would to this Act?
Absolutely. So we have to keep in mind that this Act really applies to any corporation that collects or processes personal information, no matter the size. It goes without being said that multinationals likely have to have more in-depth procedures and policies, given their sheer size, complexity of their organization, and the likelihood that they're treating several types of personal information. However, it should just always be kept in mind that Act 25 applies in the same way to all corporations.
So if a company...
Yes, we in fact have a question from one of our viewers that even a nonprofit organization that is membership based would be subject to the Act.
So that's a great question. It actually depends on this nonprofit's activities. So if their activities are kind of akin to a business, or there are transactions, and I mean, you don't have to transact to be subject to the law. But if I give a practical example, there's a difference between running a clothing drive and simply donating the clothes to the poor and having that as your mission for your nonprofit versus a more structured nonprofit that's, holding significant fundraisers, raising thousands of dollars, and collecting information from the public regarding these donations, and then, giving these donations to a foundation or to support a cause. So in some cases, long story short, the Act can be applicable to nonprofit organizations.
So if a company doesn't deal directly with individuals, but only with other companies, so business to business instead of business to consumers, is this kind of business also applicable to the Act?
Very good question, because the answer is very likely yes. The obligations under the Act would apply to such a company if they're processing personal information while providing their services. Or one that's often forgotten is the treatment of their own employee personal information. So while the focus of compliance seems to be customer information, Companies should not forget that they collect and regularly use their employee personal data. And in those cases, employee information that's transferred to third parties, let's say to a payroll specialist, for example, will be subject to further obligations that we'll touch upon a little later in this presentation. So no matter what type of organization you run or corporation you run, this act will likely be applicable to you. And please don't forget that you collect employee personal data, and that needs to be properly managed.
So we mentioned earlier that some obligations have already come into force as of September 2022. Can you give us an overview of what a company should already have in place to be compliant, maybe starting with the person in charge of the protection of PI, or as we even often heard, the privacy officer?
So definitely naming your privacy officer is one of the first things that a company should do. And it's a measure that came in, or an obligation rather, not a measure, that came into force last year. As a refresher, we have the key measures up on the screen here, and we're just going to quickly go into more detail as to what they entail. So again, coming back on the privacy officer. So this person's title and contact details should appear on the company website, assuming that the company has a website. If not, it has to basically be available to the public in some way. I have a lot of clients actually ask if they need to publish the person's primary contact details or the primary email address that the person uses, for example, jodychakraborty@bcf.ca, or if they can create a new email address. And actually, the answer is that a new email address can certainly be created, and it's actually encouraged if it's going to help from an organization perspective, and it'll bring privacy-related matters to the attention of the officer in a more efficient way.
In order to better understand this position of the privacy officer, what would normally have this role? What would be his role? Does the person need special training, certifications?
So that's actually a great question. No special training is required. However, it is important to note that the privacy officer is in charge of ensuring the company's compliance with the Act and overall operationalization of the company's strategy and action items to ensure compliance with the Act. By default, the person with the highest authority within the company, so let's say the CEO, is the privacy officer. But this title can be delegated in whole or in part to an employee or an external party in writing.
So another obligation that came into force as of 2022 is to implement a confidentiality incident register. First of all, can you help us understand what is a confidentiality incident and provide us with some examples?
Absolutely. So the term confidentiality incident is actually defined very broadly in the Act, and it includes unauthorized access, use, communication, as well as a loss of personal information. Practically speaking, let's look at what each of these would be in a practical scenario. An unauthorized access may look like an employee accessing information of another employee without having the access or authorization, meaning it's not within their scope or their job description. Or let's say a hacker. An unauthorized use is any use that's outside of the purpose of the consent that was given. So, for example, collecting personal information to provide a service, and then later using that information for marketing purposes when consent was not obtained for that purpose. An example of unauthorized communication would be, let's say, the transmission of personal information by email to an unintended recipient. And the loss can obviously occur if data wasn't backed up and there's a server failure.
So when faced with an incident, what steps must a company take in order to assess the situation?
So some of these steps are obviously kind of gut reactions that companies probably already take, but there's a few more that are now imposed by law. So companies are expected to take reasonable measures to mitigate the effects of the incident. And I think that one is something that's probably already done as instinctually by corporations. The next is to keep a written register that documents the incident. And if that incident actually incites a risk of harm, there's another obligation to notify the Commission d'accès à l'information, the Commission.
And Jyoti, you mentioned that an incident that incites a risk of serious harm. What would constitute a risk of serious harm, and is it defined in the Act?
So, interestingly enough, it's actually not defined in the Act, but it's determined on a case-by-case basis. It's based on the scope of the personal information subject of the incident, the number of people affected by the incident, if the information was sensitive or not in nature. So let's take, for example, wrongful dissemination of somebody's birthday or a list of birthdays versus SIN number or health information. And lastly, you need to assess the likelihood that the information will be used for harmful purposes.
So we know that now businesses must have this confidentiality incident register, but what information does it need to have, and how long does a business need to keep it?
So the Commission has actually provided guidelines on what the register should minimally contain. But if we're looking at a high level, it should document the type of personal information that was, wrongfully disclosed. It should have the type of or a description of the actual incident itself, the date on which it occurred, and the people that were affected. You can definitely check out the guidelines provided on the Commission if anyone's interested to see what the register should contain. Also, we do stress, though, that the register should be in written form and should be conserved for at least 5 years following the incident. A practical recommendation that's not in the law, but that we recommend, is that it should be stored on 2 separate mediums.
So finally, another obligation that came into force as of 2022 is regarding the use of biometrics. First of all, what is a biometrics? And on a high level, what should a company have to do in order to be compliant with the Act regarding the use of biometrics?
So the use of biometrics could actually be subject of its own presentation, but let's cover it at a high level. When you say biometric process or system, you lose people. So let's get into what it actually is. It's a process or a system that measures and analyzes people's physical and behavioral attributes. Let's say facial feature, voice pattern, fingerprints, palm prints, and even structures of the eye, so iris or retina. And if such measures are used, the Commission must be informed no later than 60 days prior to the use of the processes or systems. And there's actually separate obligations if you're going to keep a bank of this information, but we're not going to get into that because it's quite complex. And also, you need to be sure that there's kind of an immediate notice that such process or system is in place, and you need to obtain explicit consent from the concerned individuals.
So if we now talk about 2023 and the most recent obligations of Act 25, one of the main reasons the Act made so much noise in the media are the sanctions. So what happens if a company hasn't implemented anything yet? Should they be worried? Also, are the penalties going to reach the maximum mentioned on the screen, or will the Commission d'accès has established some criteria?
So the truth is that there's no clear written guidance from the Commission on this matter, as of now at least. We may have further guidance going forth. So we assume at this moment that the assessment will be done on a case-by-case basis. Every company should be taking Act 25 very seriously and taking active measures towards compliance, if not already done, given that there's really limited visibility on how the sanctions may be imposed.
So several key new requirements came into force. It might be more worrisome for a business. So first of all, what would you tell a company worried about Act 25?
I know a lot of you are sitting there right now watching this webinar thinking, oh boy, where do I start? So we actually recommend starting by preparing a personal information processing registry. And I'll get into what this tool is. It's a non-obligatory tool that I'll explain a bit more. But I'm going to use this opportunity to say that we understand that all of this may seem very complex, but we think it's important to take in the information, digest it internally, and come up with a plan. Simply by tuning into this webinar and understanding the key obligations under the Act, this is your first step towards compliance. The journey is not meant to happen overnight. Rather, a proactive plan needs to be put in place, keeping in mind your business reality and your landscape. So the message here that I'm giving to you is one step at a time.
Perfect. And I guess the first step would be creating the personal information processing registry.
Correct. So as I mentioned before, the processing registry is not mandatory, but it's an essential tool for your business. It will assist you with understanding the categories of personal information that are used by your business and its life cycle from collection to destruction, as you can see on the slide here. This analysis and reflection will help guide you as to what measures need to be taken and safeguards and policies need to be put in place to make sure that you're compliant with the law.
And concretely, what would a processing registry look like for a company?
So at a very high level, it outlines the type of personal information that's used by a business, how it's collected, the purpose of collection, the data processing activities, how the information may be shared with affiliates or third parties, technical storage methods and safeguards, consent records, an inventory of internal and external policies related to collection, use, transfer, and destruction of the personal information, just to name a few.
So once the processing registry has been completed, the business is now ready to draft its privacy policies. So what information must be or should be included in the privacy policies?
So at this stage, I think it's important to note that companies should be focusing on internal and external policies. And what does that mean concretely? Well, it goes back to the objective of Act 25, which is transparency. So it means being transparent regarding your customer-facing practices, regarding consents, withdrawals of consents, complaint handling, security safeguards that you have in place, and details regarding, storage, transfer, and destruction of the held personal information. But also, on the flip side, internally, ensuring that you have the appropriate documented internal processes, so SOPs, in place to manage the use of personal information within the business. And I think that that's something important. A lot of clients today are focusing on the external policies, which is very inherently important, but to really ensure holistic compliance with the Act, there needs to be the internal processes that are documented and followed so that businesses can control and organize the way that personal information is collected and processed internally.
So where should these policies be publicly, sorry, let me rephrase. These documents, should they be publicly available or only for internal use?
So I made this distinction before between internal and external policies. So while all internal policies don't need to be made public, the individual, again, going back to the concept of transparency, must be able to consult your organization's privacy policies online and understand how their personal information is being used and what measures and safeguards have been put into place to ensure that it's only being used within the scope of the given consent.
So one of the new obligations from 2023 is the conduct of privacy impact assessment, or as we say, PIAs. So first of all, Jyoti, what is a PIA, and in what context or situations must a company conduct one?
So this is actually a completely brand new concept for Quebec, but it's something or a tool that's being used in Europe under the GDPR. So this PIA is essentially a risk assessment. It's a tool that's used to assess, weigh, and mitigate risks in certain circumstances that may otherwise cause protection of PI to be weakened or made vulnerable. Practically speaking, it actually just provokes reflection internally to determine whether or not measures need to be put into place to better protect personal information. In some cases, that may mean anonymizing information prior to a transfer or simply encrypting data upon the transfer.
And Jyoti, would you recommend our viewers to document this type of assessment, or rather an informal internal assessment is sufficient under the Act?
So while the Act doesn't explicitly require a PIA to be documented, it is recommended to document this type of assessment because the Commission can come ask for proof that such assessment was conducted. In these cases, it's obviously best to have written record, and also it's in line with the written requirement to have these type of assessments written under the GDPR. So all this being said, although it's not an obligation under the law, the general guidance in the industry is to document PIAs.
So we can understand that the obligation to carry out a PIA can come up quite frequently. First of all, when is it required, and what would be your advice on the subject to make it easier for a company to conduct PIAs?
So given that this is a new obligation that needs to be kind of properly understood and implemented, I want to ensure that we're giving all our viewers today the rightful opportunity to understand the mechanics of the assessment itself. So I just wanted to let you know that BCF will be doing a detailed workshop on PIAs shortly, and the details will be to follow. I invite all our viewers to stay tuned and attend this workshop because we're going to go into detail on when the PIA is required, what it needs to cover, and practical ways to complete these assessments internally.
Jyoti, a question that comes up often is, would this new obligation or this requirement also apply to past projects?
Yeah, so you know what? That's actually a great question. And clients do ask me this probably on a weekly basis. So the answer actually is it doesn't apply to past projects, but there's obviously a caveat. It will apply if there's changes made to an IT system or electronic services that are already being rendered, or if there's a continuous transfer of personal information outside of the province. So, for example, going back to our payroll specialist example from before, let's say a business uses a payroll specialist that's located in Ontario, and there's obviously personal information that's collected at the main office that's located in Quebec that needs to be transferred to the payroll specialist in Ontario. Even if that existing supplier relation dates back to 2019, because there's a continuous transfer of data outside of the province, a PIA would be required for this project or this relation.
So some of the new obligations that came into force in 2023 have to do with the use of certain technologies. Can you tell us a little bit more about them?
Again, Gab, while all of this could be subject of an entire presentation on its own, let's go through a few of the new obligations just to give our viewers a little overview of what these new obligations are related to technology. So the first one that we'd like to touch on is enabling the highest level of technology without the user actually intervening. So think of a mobile application or a customer login interface. You want them to be able to use the application or the login without having to check off a box saying that, you know, their information is going to be protected with the highest level of confidentiality. So that's the first one. The second one has to do with functionalities on a website or an app that serve to identify, locate, or profile. So here we're really dealing with cookies. So all of these cookies must be disabled by default. However, I want to add here that options to allow users to select preferences and activate functionalities is permitted. So while the default is disabling, there can be an enabling feature with active actions. The last one is computer-aided technology. So let's take into consideration AI. That's a hot topic nowadays. So let's say your company is using AI for decision-making purposes. The concerned individuals must be informed that the technology is being used no later than when they're informed of the decision itself. So to give a practical example of this, let's say somebody is going in for a credit assessment because they want to buy a car. So if an AI is being used to kind of validate or assess that credit assessment, when the person is given the results of whether they're approved or not, they need to be informed at that time that AI was used to come to that decision.
So obtaining consent is the basis for a company's collections and process of PI. Can you give us the criteria to obtain valid consent under the Act?
So obtaining consent was already an obligation under the old Act, but now there's a few more criteria to obtain valid consent under Act 25. So the guiding principles are that valid consent must be clear, free, informed, and clearly indicate the purpose of the collection. In practical terms, it's best to use plain and clear language that explains the purpose of collection and the use of the personal information. One of the primary objectives of the Act, as mentioned before, is transparency, and I'm going to keep saying it, be transparent. So this should always be kept in mind when assessing whether or not a consent is sufficient or not, or the language of consent is sufficient or not. It should also be noted that when we are dealing with sensitive personal information, so such as health records, SIN number, obviously, characterized on a case-by-case basis, that explicit consent is required.
So without specific consent, could a business use personal information that, let's say, I make publicly available? So for instance, my email address is available on my LinkedIn page. Could a company use it?
That's a great question, but you're safe because the answer is no. In this case, the individual's consent was not obtained by the business in relation to the use that they're going to use it for the intended purpose by the business. So let's say they were collecting your email address for targeted marketing or targeted advertisement. You did not give your consent for this, so the business could not validly use that publicly available information.
So Jyoti, I understand without obtaining proper consent, the legal consequences could be important if it's not obtained in conformity with the law. So could you discuss what these legal consequences would be and who could complain?
Yeah, so if we go back to the Act itself, we spoke about right at the top that individuals have more rights under the Act. And this is not a new right, but an extended right. That individuals have the right to file a complaint with the Commission. And once this occurs, the next kind of step will be an investigation by the Commission, and businesses will likely be sanctioned if consent was not properly obtained. And as we touched upon earlier, the penalties under Act 25 are quite serious. So implicitly important to obtain proper consent, and that goes without being said.
So I think it's important also to mention that the Act provides some exceptions for the obtention of consent.
There are indeed some exceptions to the use of personal information without obtaining consent. And they are the use of personal information for the purposes of evaluating or enhancing IT protection and security measures, disclosure in the context of a business transaction. So for example, you're entering into an asset purchase agreement where you're doing a transfer of a client list. In that case, the additional consent would not be required. Or if the information is communicated to a subcontractor or supplier, but that last exception is subject to some conditions that we will discuss next.
So yeah, picking up on what you just mentioned, what are these conditions and what measures must be taken?
So before transferring information to a service provider or a subcontractor, it is possible in certain cases to do so without obtaining explicit consent. And these are situations where, one, there's an assessment done of the service provider or supplier security mechanisms and privacy policies. And as you may know, this is probably already done internally by a few businesses, but this is what we usually call the IT or the tech audit. And this really looks at the different security measures that they have in place and the safeguards that they're going to be using. The second being a data processing agreement. And this is put in place to manage the transfer and use of the information by the subcontractor or the service provider. Again, it's going back to the notion of consent. Consent is given for a purpose. So you want to make sure that the personal information is always being used for that purpose. And this data processing agreement helps manage that relation. And the last is conducting a privacy impact assessment, so a PIA, going back to what we discussed before. And a PIA must be conducted in two different scenarios. One, if the service is being provided electronically, for example, SaaS solution, or if the personal information is being transferred to a subcontractor or a supplier outside Quebec, or if this Quebec-based subcontractor or service provider is transferring information outside of the province. So once the PIA is conducted, the kind of conclusions of the assessment should be translated and included in the contract with the subcontractor, namely to account for any additional security measures that must be taken.
So in light of the transparency objectives of the Act, as of 2023, there's new rights that are given to the individuals who consented to the use of their PI. Can you give us an overview of them?
Yeah, so definitely. Individuals obviously have the right to access their personal information, and this right is actually about to be further extended in 2024, but we'll touch on that a little later. They also have the right to rectify their information, and they have the right to obtain details about how their information is being processed by a company.
So 2023 was the year with many of the obligations that came into force, including the sanctions. The last wave of Act 25, for which some obligations will come into force, is September 2024. Can you give us some cues on what will happen?
Yeah, absolutely. So the good news and the bad news is that the bulk of the obligations for businesses came into force in 2022 and 2023. The main obligation that's going to come into force in 2024 is the right to portability. So this will actually extend the right of individuals to have access to their information, as businesses will then have the obligation to provide, at the individual's request, their information on commonly used technology formats.
So that would conclude the webinar. Time passes by really fast. I'd like to thank Jyoti and Gabrielle for this insightful discussion on a rather complex and evolving issue surrounding privacy compliance. We hope with this webinar, it has given you a better understanding of, or at least demystified in part, the practical implications of Act 25 on your business operations. As mentioned by Jyoti earlier, given the limited time that we had today to discuss a plethora of issues, we take this opportunity again to invite you to our upcoming workshops pertaining more specifically to the DPAs that we discussed, contracts, PIAs, confidentiality incidents, and we will also have various guests join us to share practical examples. So we really hope to see you there. And that would be our time for the question period. Jyoti, I have many questions come in regarding policy officer. And when you mentioned earlier that the contact details should appear on the company website, we have questions regarding specifically what contact information should be published. Does the name of the person have to be there, or a title is sufficient? As well, do we need to publish a phone number, or would the email be enough?
So those are all really great questions. Basically, you only need the title to be published of the person on the website. You don't actually need a name. And in terms of contact details, you don't need to have a phone number necessarily. You can just have an email address. And as I addressed during the presentation, you can actually have a separate email address kind of created that's like privacyofficer@abccompany.com. That is published on the website that's used specifically for that purpose.
And would the name and the contact details of this policy officer need to be registered with the CAI, the CAI? Or do we need to inform the CAI of this contact person, or is that not an obligation under the Act?
No, that's not an obligation under the Act. Simply publishing the details on your website or making it publicly available is sufficient.
Regarding the PIA, as we mentioned, it will be part of a more detailed workshop that's upcoming. But generally, can we provide the viewers with maybe resources or tools that are currently available to understand really what is part of this assessment?
So absolutely, the Commission actually has come out with a guide on privacy impact assessments and what they expect to see in such a report. Obviously, because it's a guidance tool, it's not exact, but it gives a pretty good kind of overview over what the Commissioner might want to see if they ask for a record of your privacy impact assessment.
We have a question regarding medical information.
Yeah.
When we mean the use of personal information, does storing this medical information in the medical records need consent, for example?
So I think there's actually two legislation that are applicable here, because there is, I know, a separate legal framework related to medical documents and medical records. So I think that would need to be looked at as well. But storing it, I don't know if I quite understand. So storing it as a medical record, is that what the person asked?
Yes, if storing the medical information in the medical record would need consent.
Okay.
Yeah.
So I don't believe so, because if we're talking about the person's own personal medical record, it kind of goes without being said that, any data that's documented will appear in their governmental register. But as I said, I think that medical records are subject to another kind of legislative framework, and both would need to looked at in parallel to answer this question.
Great. We have an interesting question from one of our viewers. When does confidential information need to be erased or destroyed? Does it have to be kept inaccessible, or can it be kept on a server?
So that's a really great question. So here we're really talking about personal information. So I'm going to kind of carve out personal information from confidential information in this case. And if we're dealing with only personal information, doing what we said, creating that registry will help you understand and create policies on when it needs to be destroyed. Because basically an assessment needs to be done on, okay, when is this information being intake? So what is the intake process? What is the collection process? What is the purpose of collection? And then based on the purpose of collection, you can determine when it kind of can be destroyed. If we're going back to, let's say, personal information of an employee, let's go back there. Obviously, it's the intake process is when the person starts their employment. The purpose of use obviously is for, the maintaining that employer-employee relationship and kind of managing that, whether it be payroll, benefits, insurance, all of that. And then you need to ask yourself kind of, what would be the natural date that you could purge this information? Well, the answer might be the date of termination, whether the employee leaves or is let go. But also you need to think about employment and tax laws as well in that case to see, is there any other law that requires you to keep the information past the date of termination? So I think at a high level, important to do the registry and get an overview and map out when the information is coming in, and ask yourselves internally, what is the purpose? Because that'll give you the answer as to when you can purge or de-anonymize actually the information.
I have lots of questions coming in regarding the presentation and whether we'll be sharing its content. So yes, we will in fact be sharing a key summary of the new obligations and Act 25 over the course of the coming days. And you will also receive a link to watch this presentation. So yes, we will in fact be doing so. As to the details of the workshops, we will be sending out details as to whether it will be in person or via webinar. So all details will be communicated and made available shortly. Jyoti, coming back to PIs that are shared outside of Quebec, would consent be required if a company does so?
So no, consent is not required in certain cases, obviously, that we listed during the presentation. So let's say there's a transfer of data that's subject to the DPA, so the data processing agreement, a privacy impact assessment is conducted, and there's a kind of IT and security audit done of the supplier or subcontractor's IT framework and security measures that they're taking.
Okay, I'm just looking here. We have a question regarding GDPR. So Jyoti, could we merge the requirements and efforts of GDPR document retention in Act 25?
That's a interesting question. And I think that the answer is probably more complex. Although Act 25 follows the GDPR, I don't think that we can just take the stand of, and I think that honestly GDPR is probably has stricter obligations sometimes than Act 25. But I don't think that we can take the stand of, okay, if we're only going to follow the GDPR and not follow Act 25, I don't think that's the right way to go about it. Can there be an internal reflection on what are the main obligations under both laws, and what processes in common can we have in place? I think that's kind of the better way to go about it.
Okay, I'm looking here. If you have specific questions regarding your business, as I mentioned earlier, we would be happy to take contact you and discuss the more particular nature of your business due to the limited time that we have today. If not, I don't know if there are any other questions from the viewers, participants. I'm just refreshing here. I think that would conclude on our end, unless there are any further questions.
Okay, well, actually, Othana, I'd like to take a second then and just kind of reiterate what we said during the presentation to the viewers. We totally understand this is a lot of information to take in. Please use our summary that we're going to send out later on to kind of fuel internal discussions at your business to figure out, you might already be partially compliant with some of the measures that you already have in place, but to figure out how they need to be tweaked or what additional measures are required. We really hope that this kind of fuels that discussion and that positive action can be taken towards compliance. And don't forget, obviously, BCF is here to guide you through this process. So after your internal reflection, if you need help on determining what actual action items and what steps and what documents you need to actually put in place, we're obviously here to guide you.
Is there any more questions, Audrey-Anne?
There are no more questions. I think your presentation was that was quite enlightening. So I think that would conclude our presentation on our end, unless there are any last questions. No, there doesn't seem to be. Thank you again, both Jyoti and Gabrielle, for this amazing discussion, and we look forward to seeing all of you in our upcoming workshops. So stay tuned. Thank you and have a great day.
Thank you very much.
Thanks.